All right, Friday, Judge Cowell issued an arrest threat from the bench against a sitting president's legal team. That's not a headline I expected to write this week. Court filings from Wednesday lay out exactly what happened. I've been going through them. Here's what I found. According to official court transcripts, the confrontation wasn't spontaneous. It built over 11 days. Small escalations, ignored deadlines, a defense team that kept pushing. Then Thursday morning, Judge Cowell stopped being patient. You saw the clips, the heated exchange, the raised voices. Here's what the clips didn't show. There were 47 pages of filings underneath that moment. The backstory is what matters. Let me walk you through it. Quick context. Judge Cowell, federal district court judge, presiding over a case directly tied to Trump administration policy enforcement, a civil contempt proceeding that started as a procedural disagreement and turned into something much bigger. The issue? Trump's legal defense team missed court-ordered compliance deadlines twice, then disputed the authority of the court to enforce them. That second part is what lit the fuse. Timeline, fast version. 3 weeks ago, first compliance deadline set. Defense acknowledged it in writing. 2 weeks ago, deadline passed. No compliance, no formal response to the court. Last Monday, Judge Cowell issued a written warning, specific language, specific consequences listed. Wednesday, defense filed a 31-page motion arguing the court lacked jurisdiction to compel compliance at all. Thursday morning, hearing called. What happened in that courtroom became the story. That's the setup. Now the documents. Because what's in those filings is not what either side wants you to read carefully. Okay, the evidence. First document, filed Wednesday. I pulled page 14. It says, quoting here, respondents have failed to demonstrate good faith compliance or provide substantive justification for continued non-performance. That's not my characterization. That's the court's own language, Wednesday's filing. What it means? The judge already concluded in writing that the defense wasn't just late. They weren't trying. But here's what got me. Page 22, different section entirely. Defense counsel filed a footnote, footnote 7, page 22, arguing that presidential immunity doctrine, as extended by recent Supreme Court precedent, creates a compliance shield during active executive functions. A footnote, that's where they put it. I went through this filing 3 times. That argument, buried in a footnote, is actually the core of their entire position. They just didn't lead with it. Put those together, yeah. The defense knew the deadline argument was weak. So they planted a constitutional escape hatch in the margins and hoped nobody would pull it out. The judge pulled it out. Wednesday's motion, 31 pages arguing jurisdiction limits. Footnote 7, immunity extension argument, 4 sentences. Judge Cowell's response filing cited footnote 7 specifically 8 separate times. All documented, all in the public record. Now, what nobody's covering, the compliance the court originally demanded wasn't classified material, wasn't executive privilege territory. It was financial disclosure documentation related to a $2.3 million federal contract, a procurement contract. Defense argued that even that falls under the immunity shield during an active presidency. Read that again. A procurement contract compliance filing. That's the hill this defense team chose. And Judge Cowell's response, also in Wednesday's filing, page 31, used the phrase contempt of this court's lawful authority 4 times in 2 paragraphs. Federal judges don't write like that by accident. Fallout so far. Defense team's immunity argument, immediately flagged by the court clerk's office as requiring emergency review. 3 separate federal oversight bodies received copies of Wednesday's filing within 6 hours of submission. The White House legal counsel's office has not publicly commented, but two sources familiar with internal discussions cited in reporting from Thursday evening describe internal communications as tense. Within 18 hours of that filing, that fast, the documents don't say the defense is wrong. They say the defense made a calculated bet that a bold constitutional argument would delay enforcement long enough to matter. What they may not have calculated, Judge Cowell has presided over 23 federal contempt proceedings. He's held parties in contempt in 19 of them. That's not nothing. That's just the first document. I've got two more. Subscribe. I'm not done with this one. More filings dropping this weekend. I'll break them down when they hit. Okay, but look, gotta be fair here. The other side has a point. Actually, several points. And some of them hold up better than the coverage suggests. Trump's defense team says this entire proceeding is an overreach, that a federal district court judge doesn't have the authority to compel compliance from a sitting executive on matters touching executive branch operations, even indirectly. And honestly, that's not a crazy position on its face. Their argument breaks down like this. First, the Supreme Court's 2024 immunity ruling created genuinely unsettled law. The boundaries of what a president can and cannot be compelled to produce in civil proceedings are not fully defined. Defense counsel isn't inventing this ambiguity. It exists. Real constitutional lawyers disagree about where the lines are. Second, the timeline the court used to establish non-compliance included a period when key members of the legal team were engaged in separate, parallel proceedings. Defense argues the deadlines were practically impossible to meet, not deliberately ignored. A former Deputy Assistant Attorney General with 14 years in the DOJ's Civil Division put it plainly. Courts sometimes set compliance timelines without accounting for the realities of executive branch document management. Don't dismiss that. A 31-page motion doesn't get filed because lawyers have nothing to say. What they've got going for them? At least two circuit court precedents support narrower interpretations of district court contempt power over executive actors. The original compliance order was issued on an expedited basis. Defense argues insufficient time was built in from the start. Even a retired federal magistrate judge, not affiliated with either side, told a legal news outlet Thursday, the immunity argument in footnote 7 is aggressive, but it's not frivolous. Look, I'm not here to tell you who's right. I've read the documents on both sides. The Trump defense team interpretation, there's legal foundation for it. Thin in spots, but it's there. Judge Cowell's interpretation, the evidence supports it more directly. Both things can be true. That's what makes this legally significant rather than just politically loud. What I can tell you is what the documents show. And they show a judge who took the footnote argument seriously enough to respond to it 8 times and then scheduled a hearing anyway. When a federal judge schedules a hearing after already putting the contempt language in writing, that's not routine procedure. That's what we need to talk about next. This didn't come out of nowhere. Backstory quick. About 8 weeks ago, the original civil case was filed. Procurement dispute with a federal contract. Standard administrative matter initially, expected to resolve in 60 days. 6 weeks ago, Trump's legal team entered an appearance. Case immediately changed character. Motions began challenging basic procedural authority of the court. 4 weeks ago, Judge Cowell issued his first scheduling order. Defense responded by filing a motion to stay all proceedings, pending an appeal that hadn't been filed yet. Someone even said on record in a hearing 3 weeks ago, this court should not proceed as though ordinary rules apply. Defense counsel said that out loud in open court. The transcript's public. What happened? Judge Cowell denied the stay, set the compliance deadline, put consequences in writing. Pattern. Challenge the court's authority at every procedural step. File motions that delay without technically refusing. Escalate the constitutional argument only when deadline pressure becomes real. Every time, the tactic bought days, sometimes weeks, until Wednesday's filing landed and Judge Cowell stopped treating it as procedural maneuvering. That's when this stopped being a procurement dispute and started being a constitutional confrontation. Following the trail so far? Hit like. It tells me this breakdown format is working. Still got the climax, what actually happened in that courtroom Thursday morning. That's next. Thursday morning, 9:47 a.m. Here's what happened. Judge Cowell opened the hearing by reading directly from Wednesday's filing, not summarizing it, reading it. Then he looked at defense counsel and said, transcript, page 3, line 8. This court will not permit its authority to be footnoted away. Room went quiet. Observers described it as immediate. What followed? Defense counsel attempted to pivot to the immunity argument as the primary motion. Judge Cowell cut that off, said the immunity question would be addressed, but not before compliance status was established. He then stated, on record, that continued non-compliance after today's hearing would result in a contempt finding, and he would consider custodial sanctions for the responsible parties. Custodial sanctions, that's the legal term for arrest and detention. Said it in open court, on the record. 40 minutes later, defense requested a 72-hour recess to consult with clients. Judge Cowell granted 48 hours, not 72. That's the difference between a judge managing a calendar and a judge making a point. Now, what everyone focused on was the arrest threat framing in the headlines. But something else happened in that same hearing while cameras were on the soundbite. Judge Cowell also ordered the court clerk to forward the full case file, including all motions, responses, and his own written orders to the Judicial Conference of the United States for review. He self-reported the case up the chain. That's not reactive. That's a judge protecting the record. You can see it in the clerk's notation filed Thursday afternoon. Public document, it's there. This is where it gets interesting. Don't go anywhere. What I cover next changes the picture on where this goes legally. Drop your prediction below. Does this reach contempt enforcement, or does defense find an exit? Comment now, see how it plays out. What are legal experts saying? A former federal prosecutor who spent 11 years in the Southern District of New York. Custodial contempt threats against counsel are rare. Judges use them when they've lost confidence in good faith. Plain English, Judge Cowell isn't bluffing for effect. He's signaling that he believes the delay is intentional strategy, not logistical reality. Another one, a constitutional law professor at a major research university who has testified before Congress on executive power limits. The self-referral to the Judicial Conference is the more significant act. That creates an institutional record that outlasts this proceeding. Key there. Even if the case settles or gets appealed away, the Judicial Conference record doesn't disappear. It follows the legal questions into whatever court takes this next. Here's what's interesting. Even a former senior counsel for the White House counsel's office, someone who has defended executive privilege claims, acknowledged Thursday, footnoting your core constitutional argument creates problems if you later need to argue it was central to the case. When someone who has been on the defense side of these arguments says that, pay attention. Consensus among legal analysts who've reviewed the public record. The contempt threat is credible and procedurally supported. The immunity argument may be valid on appeal, but won't prevent a contempt finding at the district level. The Judicial Conference referral signals this judge expects this to be reviewed above him. That's where serious legal professionals land right now, not partisan commentary. That's what people who've worked these proceedings for decades are reading out of Thursday's transcript. Useful breakdown? Hit like. Takes 2 seconds. Helps this reach people who are actually trying to understand the legal mechanics, not just the headlines. Why should you care about a procurement contract dispute? Real talk. Here's how this touches actual people. This is a precedent case, whether anyone wants to call it that or not. The question being litigated right now, in real time, is whether a sitting president's legal team can use immunity doctrine as a compliance shield in civil proceedings that don't directly involve presidential acts. Next time you're in a dispute with a federal contractor, or a business that has federal contracts, or a company whose executives claim any kind of institutional protection, the outcome of this case affects what courts can compel. That's not abstract. That's contract law touching millions of business relationships. The $2.3 million procurement contract at the center of this, that's federal money, taxpayer money. The disclosure documents the court is trying to access relate to how that contract was awarded and executed. If courts can't compel disclosure on federal contract compliance, even $2.3 million ones, the enforcement gap becomes a template. Right now, roughly 340,000 active federal contracts are in some stage of compliance monitoring. That's the scale of what weakened enforcement authority touches. If you work for a company that holds federal contracts or competes for them, this matters directly. Compliance requirements and enforcement mechanisms are the foundation of that entire market. If those requirements become unenforceably complex for politically connected actors, the playing field shifts. Businesses that play by the rules absorb costs that others can footnote their way around. That's not drama, that's procurement economics. Here's the uncomfortable part. The delay strategy, challenge authority, bury the real argument in a footnote, request extensions, works. It has worked in this case for 11 days already. It may work longer. Courts are slow. Appeals are slower. By the time a final resolution lands, the underlying facts may be moot. If you've ever watched a legal process drag out long enough that the outcome stopped mattering, you already understand why this pattern exists. The documents don't prove bad faith, but they describe a timeline that is very difficult to explain as coincidence. What informed people are doing right now, watching whether the 48-hour deadline produces compliance or another motion, tracking whether the judicial conference acknowledges the referral, asking their own legal counsel what this week's transcript means for ongoing federal contract disputes. Not advice, just what I'm seeing people pay attention to. Knowledge helps, especially before this gets buried under the next news cycle. How did Trump's team respond publicly? Made it more complicated, honestly. By Thursday afternoon, a spokesperson released a written statement characterizing Judge Cowell's contempt threat as judicial intimidation and an unprecedented attack on the constitutional separation of powers. Quote from that statement, "No court has the authority to threaten executive branch counsel for asserting legitimate constitutional defenses." Reaction was fast and split. Statement shared over 180,000 times across platforms within 4 hours. 3 legal commentators with significant followings publicly challenged the unprecedented framing, citing 2019, 2011, and 2004 cases where contempt threats were issued against government-adjacent counsel. Judge Cowell's office did not respond publicly, which is normal. Federal judges don't respond to press statements. But the court docket updated Thursday evening. New entry. Court affirms 48-hour compliance window. No extensions will be granted without cause shown at emergency hearing. That was filed at 6:14 p.m. That's not a response to the press statement, but the timing makes it readable as one. The spokesperson's statement used the word unprecedented 4 times. The court docket update used 0 words, just a timestamp and a deadline. Not cooling down. The 48 hours started Thursday evening. What's still genuinely unclear: 1, whether defense counsel will file for an emergency appellate stay before the 48-hour window closes Saturday evening. That's the most likely procedural exit, but it requires a circuit court to move fast on a Friday heading into a weekend. 2, the judicial conference referral. We don't know what they received. The referral itself is documented. The contents of the case file forwarded are not publicly confirmed beyond what's already in the public record. Coming developments. The 48-hour compliance deadline hits Saturday evening, June 7th. Defense counsel is reportedly in contact with the 11th Circuit as of Thursday night, at least according to two legal reporters who cover that court regularly. The White House counsel's office has a scheduled briefing on Monday, June 9th. Unrelated matter on the calendar, but expect questions. Date to watch, Saturday, June 7th by 6 p.m. If compliance happens, this de-escalates. If another motion lands instead, we're in new territory. Subscribe. I'll cover the Saturday deadline the moment something moves, whether it's compliance, an emergency appellate filing, or something none of us have mapped yet. I'll break it down the same way I broke down today's documents. Subscribe to catch it. Where we are right now, Friday, June 6th, 48-hour compliance window is active. Deadline, Saturday evening, June 7th. Judge Cowell's contempt threat is on the official record. Public transcript, page 3. Judicial conference referral confirmed by court clerk notation Thursday afternoon. Defense public statement issued. Judicial intimidation framing. No emergency appellate stay filed as of Friday morning. Scheduled. Saturday, June 7th, around 6 p.m. Compliance deadline expires or compliance is submitted. Monday, June 9th. White House counsel scheduled briefing, other matter, but relevant context. Week of June 16th. Next regular hearing date on the underlying case, assuming no intervention. Not public yet, whether the 11th Circuit has received or acknowledged any emergency contact from defense counsel. That would move fast if it happens. I'm watching the docket. Clock is running. 48 hours is not a long window. And federal courts don't grant extensions on language they've already put in writing. That's where we are. Judge Cowell, on record, deadline set, judicial conference notified. Trump's defense team, public statement filed, constitutional argument on the table, 48 hours to decide their next move. Surface read, a dramatic courtroom confrontation between judicial authority and executive legal strategy. But the self-referral to the judicial conference is the detail that matters most long-term. That's a judge building a record that survives whatever happens to this specific case. And the footnote. Don't lose the footnote. The strongest constitutional argument in this entire proceeding got 4 sentences and a footnote number. That tells you something about how confident defense counsel actually is in it. I'll be watching the Saturday docket update specifically. Story's not over, still developing. Subscribe for the full picture, not just the sound bites. When the next filing drops, I'll read it the same way I read this one. Talk soon.